And, Indian family law is undergoing a period of tremendous flux and changes. So I think it seems to be an apt time to think about the role of the Constitution in relation to family law. And so we have a very special guest who will speak to us about this relationship between constitutional law and family law, particularly as it pertains to women's unpaid labor. So I'm delighted to welcome Dr. Gautam Bhatia, who will be presenting his work from his most recent book, one of many books, which is called Horizontal Rights and Institutional Approach. It was published by Hart Publishers last year in 2023. And so he'll be speaking from the book, and in particular, a chapter from the book. We also have two commentators who are lawyers, and I'd like to welcome them as well, both Saptarshi Mandal as well as Saumya Maheshwari, who are family lawyers. So a warm welcome to all of you, and I will hand over to Gautam, who will speak for about 25 minutes or so, followed by comments from Saptarshi and Saumya.
Thank you. Thank you. Thank you so much. I hope I'm clear and audible. It is great to be here. It's also great to be presenting for the first time this work in this forum, because while I was doing my PhD, I came across Prabha's fantastic work on the Motor Vehicles Act and the compensation that the Indian courts award in motor vehicles accidents that takes into account unpaid domestic labor. And that was very generative in me thinking through many of these ideas that finally found their way into the thesis and eventually the book. So I think what I'll do is I'll contextualize the core argument of the book as this horizontal rights an institutional approach, and flag its application to domestic work, unpaid domestic labor, or within the domestic relationship, which is one chapter, one application chapter. And then, of course, go into the discussion with the commentators. So the book arose out of of trying to reconcile two intuitions. One intuition is that there is no reason why, by default, constitutional rights should not apply to non-state relationships, to a private relationship. There is no reason, for example, why when a racist homeowner refuses to lease or sell their property to someone from a different race or religion, something common across the world, in India as well, there's no reason why the non-discrimination clause of the Constitution shouldn't apply to that relationship. It should. Intuitively, it should. That's one intuition. And the second intuition, of course, is that we don't think that every private wrong needs to be constitutionalized. So a theft, we don't think of a theft often as being a violation of the victim's right, constitutional right to property. We think of it as a crime under the penal code. So while certain kinds of violations of rights in the non-state so-called private sphere seem to warrant a constitutional solution or a constitutional remedy, others don't. And therefore, what is the principled basis for that distinction? Effectively, what could be a theory of horizontality? This is something that in recent times has caught the attention both of scholars across the world and of courts. So as far as scholarship goes, in 2014, Johan van der Walt wrote a book called The Horizontal Rights Revolution. 1 year after, Jean Thomas wrote a book, Public Rights, Private Wrongs. And so there's been an efflorescence of scholarship, both in book form and in article form, trying to conceptualize a theory of horizontality. And you can see why, because with the retreat of the state from many of its classical, late 20th century welfare functions, the potential of private actors to violate rights on a large scale has grown in recent times. And therefore, also courts have been grappling with this issue. The Indian Supreme Court, most recently in Kaushal Kishore's case, just a year and a half or so ago, attempted to craft some kind of an account of free speech being applied horizontally. The South African Constitutional Court, whose constitution has a specific provision that allows for applying some rights horizontally sometimes, recently tried to do that with private schools and the relationship between learners and private schools. The Jamaican Court of Appeal did that in the case of a gay person who wanted to air an advertisement for gay rights with two of the largest private TV stations in Jamaica and was refused on the grounds of his sexual orientation. And the Jamaican Court of Appeal finally said no, he couldn't claim under the Constitution's horizontal rights provision. The Kenyan Supreme Court and the High Courts examined this issue in the context of women not being allowed to become executive members of a private golf club. And the Kenyan High Court said that that is a claim you can make under the Constitution's non-discrimination guarantee. So across the world, specifically over the last decade, this issue of when you can hold a non-state actor responsible for constitutional rights violations, and when can you subject a private relationship to the Constitution without ultimately constitutionalizing all of private law and all of private relationships, is something that is really cutting edge in global comparative constitutional theory and adjudication. So the book is another attempt to contribute to that growing body of literature and judicial consideration. So it aims to provide both a theory of horizontal rights, which is part one of the book, and then part two is to demonstrate that this theory could be applied to actual constitutional and legal disputes by courts in a coherent and manageable fashion. So that's part two, and this chapter is one part of part two. So as far as the theory goes, I articulate what I call the institutional approach. And the basic argument there is that constitutional rights are applicable horizontally, that is to say, between private parties and private relationships, when first there exists an institution. Secondly, that the relationship between the two parties is embedded within that institution. And thirdly, when the relative institutional location of the two parties allows one to violate the other's rights. And I'll just unpack that. So, the first question is that what is an institution for the purposes of this book and this argument? And there I argue that it's broadly take the sociological definition of an institution. So a set of practices recurring over time, and that the institution is something more than just the aggregate of those practices and patterns of behavior. So it has an identity that goes, it's constituted by those acts, but it's more than the aggregate of those acts. The one wrinkle that I add for the purposes of this book is that for rights to apply horizontally, the institution must be one which you cannot ordinarily exit, or at least cannot exit with great ease. So just to take two very basic examples, it may be possible to exit a particular school or a particular workplace for a particular employee or workman or student. On the other hand, you cannot exit the institution of race. You cannot exit the institution of patriarchy, for example. Right? So you have to look at whether the possibility or ability to exit is one feature in determining whether, for the purposes of this argument, an institution exists or not. The second aspect, of course, is that the relationship that is being subjected to the Constitution flows from that institution. So again, to take your classic example of when we think constitutional rights should apply horizontally, that of a racist homeowner who refuses to lease their property on the basis of race, what we call restrictive covenanting in technical terms. So when that refusal is grounded within the institution of race, then the rights apply presumptively. On the other hand, if there are other reasons, for example, I just don't like the person, or the person is my business rival, and therefore I make that choice, then this institutional approach isn't attractive. There might be other institutions of the market and so on, but for this purpose, that institution isn't attractive. And then, of course, the final requirement is that that relative location within the institution is what allows the violation of rights to occur. So institutions assign roles and create hierarchies. And when those hierarchies enable a difference of power that allows one party to violate the other's rights, that then completes the requirements for applying the constitution to that relationship. And so, therefore, your racist homeowner falls within that equation, as do other things that we think intuitively would fall within that equation. So, in India's case, for example, Article 15, Clause 2, that prohibits discrimination in access to certain public spaces, which are always mediated by caste power and hierarchies based on caste or race or ethnicity of that kind. Article 17 that prohibits untouchability. So it is, of course, untouchability is a social institution which is founded on caste hierarchy. So intuitively, it seems to be a coherent way of identifying when you should apply rights horizontally and when you might not. That's the dividing line. Of course, there are many boundary cases. There are many cases where it will be arguable, is this institutional, is this not? Are the requirements satisfied or not? And it requires judges to engage in a reflexive analysis where you go back and forth between, levels of abstraction. So the institution exists at different levels of abstraction, and you have to bring in line the specific practice that is being complained of with the institution's more abstract features. And you go back and forth, and I discussed that, taking 3 examples in the Indian case. One where schools were held to constitute shops within the meaning of Article 15, Clause 2, and therefore non-discrimination was identified horizontally and applied horizontally. Secondly, where the prohibition of women from entering a temple was adjudicated under that touchstone of untouchability. And thirdly, where non-payment of minimum wages was held to be forced labor and therefore constitutionally horizontally applied. So I discussed how in each of these 3 cases judges have to move between levels of abstraction of the institution being at the abstract level, and then of course the practice, and then bring them in line. And that is something that you can only figure out on a case-by-case basis. So that is as far as the overall theory goes and the theoretical account goes. And in the 7 or 8 minutes that I have left, I'll talk about the application of that theory to this chapter. So the chapter before this, chapter 6, deals with the labor market, and I argue for the application of constitutional rights horizontally to platform workers vis-a-vis the platforms, the so-called employer. And so whereas chapter 6 deals with the sphere of production as classically understood, chapter 7 deals with the sphere of social reproduction, and in terms of social reproduction theory, SRT, which is a fundamental building block of the arguments that I make in this chapter. So in this chapter, essentially what I argue is that domestic relationships, the central case of which in this context is marriage, but it could expand beyond marriage, it could expand to other kinds of domestic relationships, at least as far as cisgender heterosexual relationships go, is an institution for the purposes of this argument. It is nested within the broader institution of the family. It is an institution that is hierarchical in terms of gender. So it is an institution that is defined by patriarchy. It assigns different roles by default to the 2 partners. Of course, in specific cases, those can be overcome, but that is the default that it assigns. And the differences in institutional power that flow from the patriarchal underpinnings of the relationship and of the family enables the violation of rights. And one core form that this takes is that of unpaid domestic labor that is obviously gendered in its nature, primarily performed by the female partner, even in societies where formal equality now is the norm, even in those societies, of course, is still predominantly gendered. So the requirements for the application of the institutional approach are therefore made out in this context. Many rights apply: non-discrimination, the right to property, and the right, including the right against forced labor, that I argue is also attracted. The problem then, of course, is that how do you deal with this on an application basis, especially given, and this is a problem that always occurs when we get to the application question, given that often private relationships, so-called, are also marked by a certain kind of intimacy and a certain kind of interest in allowing people to autonomously frame the terms of those relationships, even when they may not strictly conform to constitutional parameters. How do we balance those different competing factors? That's something that courts always look at, something that therefore we must take into account. And so in this context, therefore, the argument I make is that there are two possible solutions that are broadly consistent with balancing those competing interests. One, of course, is wages for housework, the classic movement for wages for housework. It's been there in multiple countries. It's recently also been argued for in the public sphere in India in a number of articles in the newspaper. But that is a claim you make against the state in most cases. So that's your classical vertical relationship between the state and the individual. So horizontal rights are not really attracted over there. But where I think horizontal rights can play a role, and this is the argument I make, is in the rules that apply upon separation or dissolution of a marriage. Now, in this context, there are two things to take note of. One is that what the default position in India and many other countries is that if, for example, the property is in a certain spouse's name and has been bought with that spouse's money or is just registered in that spouse's name, then that property remains with that spouse on separation. What the other spouse is entitled to is maintenance. And maintenance is defined broadly in terms of allowing that spouse to maintain, as the name suggests, a basic standard of living upon separation. So there is a disjunct between the unequalness that takes place in the course of the relationship itself, which we've discussed before, and what happens on dissolution. And the argument that I make is that if we have a default rule of treating the assets and the properties that are acquired in the course of the relationship as being presumptively of both parties, and so therefore departing from formal title requirements in property law, and therefore have a baseline default rule of equal division upon separation, then that is a way in which you can trace the constitutional principles and apply them to the private relationship. Now, of course, this is not an ironclad rule, and it would entail judicial discretion in various specific cases. But it can serve as a starting point, a default rule on separation. And you actually see, therefore, the role that the institutional approach can play in actual cases, which I discussed in this chapter. So, for example, in New Zealand, there was a dispute over. So, they have their Matrimonial Property Act. So, they have their division of property on dissolution, and one question was that what constitutes self-acquired property vis-a-vis marital property in the course of the relationship, because the latter then would be subject to these rules and the former would not. And the court argues that because the purpose of this statute, when it came about, was to try and recognize the equal contribution of both spouses towards acquiring property, even though it might be in one spouse's name, because that spouse is the one who has the money in the relationship because the other spouse is performing unpaid labor. Because this law was brought in to recognize that equal contribution. Therefore, when you have an interpretive doubt or interpretive gap, you interpret it in favor of equal division. So therefore, they interpreted the law when there was an ambiguity in favor of equal division, and ensuring that therefore, even though the property was in the name of one spouse, the other spouse had an legal interest in it. So you can see, therefore, that the intersection between constitutional horizontal rights of equality of property, of recognizing unpaid labor as a function of equality, intersecting with the technical aspects of the statute, and then the court using the constitution applied horizontally to interpret the statute in a way that then recognizes that unpaid contribution and attempts to equalize that relationship. I also discussed cases from Colombia and Kenya. And Colombia, again, a very interesting case where there was a spouse and the husband had passed away, and they were seeking to evict her from the property, which was in her husband's name. And there again, the court says that given the structural and institutional inequalities in the relationship, we will treat this surviving spouse as having a legal interest in that property, even though she does not have a property interest in it or property right over it, and therefore has certain protections against eviction. So I discussed cases of that kind. And in India, of course, the Domestic Violence Act exists, but its protections are quite limited. Right? So residence orders, protection orders, but that jump towards a legal interest in the property is still left to do. And I ask whether it is possible to interpret the act to do that, and I think it's not, at the moment it's not. But it shows the gap and what could happen if we apply the constitution horizontally to that relationship. Of course, one area in which it has happened, and that's where Prabha's work has been so instructive, is motor vehicles compensation cases, where in quantifying the compensation due in a motor vehicles accident, the court takes unpaid domestic labor by the female spouse and quantifies that, and then uses that to determine compensation levels. And that again shows you that it is possible for courts to do this, and having a theory that tells them or that informs them why and how to do it would then help to ground what is presently a kind of intuitive grasping towards that idea in constitutional terms and in the terms of rights. So that is what the argument is. And just to sum up, and I'll hand over. So the institutional approach argues that constitutional horizontal rights ought to be applied between private parties when there exists an institution, and the locus of the rights violation is grounded within that institution. In this chapter, I argue that the domestic relationship is an institution within the larger institution of the family. It fulfills the requirements of the institution. It fulfills the requirements of applying rights horizontally. And one way to do that is that when you adjudicate disputes on resolution, you start with a presumption of equal property of both spouses, and of course subject to individual cases. And that's one way of bridging the gap between the constitution, the law, and the relationship. So I'll close with that and hand over to the discussants. Thank you once again.
Thank you, Gautam, so much for that very eloquent, but also very accessible kind of, argument that you set out both in the book in part 1 and part 2. I think they speak very well to each other. And also for updating, all the sort of recent developments since your book was published. So that was really very useful. So now I'll hand over to Saptarshi, and then Saumya can speak as well. Yeah, thanks.
All right. Am I audible?
Okay. Yes.
Thank you, Gautam, for writing this book and for summarizing your main arguments in 25 minutes. And also thank you, Prabha, for having me here. So different parts of the argument spoke to me, and I'm going to make 5 comments. Okay, they may not add up as one, comment or critique of the book, but there are different components that spoke to me in different ways. Okay, so the first point is that the institutional approach, applying the institutional approach to domestic relations and marriage is, I think, a welcome idea. Analytically, it's useful. Also, politically, it's useful because it allows you to kind of separate the institution from the individuals. So, and it's particularly attractive for a marriage-hating family law scholar like myself. So, if I'm critiquing marriage, then I'm critiquing the institution and not people who are, I'm not basically abusing married people. So it's a welcome addition to the theoretical, kind of tools that we have to look at the family and marriage. Second point is a question about the institutional analysis and your use of the institutional analysis. So what kind of institution is marriage? Right? In feminist discussions on the institution of marriage, there are different shades. So you've used, say, people like Susan Moller-Okin and Carol Pateman, and both of them have an institutional account of marriage, but they come from very different positions. I mean, for Okin, marriage is just a sexist institution. You change the laws, you end the public-private divide, and the problem is solved. But for Pateman, it's not merely a sexist institution. It's a patriarchal institution, and it's very difficult to kind of extricate marriage, to redeem marriage out of clutches of patriarchy. So Pateman asks us to be suspicious about everything about the marriage, including the contract and this free contract that a woman kind of freely and supposedly freely enters into. So what kind of institution is it, and are these different shades of institutional analysis within feminist commentary, feminist use of the institutional analysis, are they relevant for this purpose? Take also the Foucault-inspired feminists who have a critique of the institutional approach that is just too totalizing. It asks us to think of marriage as one big whole, and that's not helpful. That's not true. There are different forms of marriage. It's not an institution. Period. And other. I'm also thinking about this Australian feminist scholar Heather Brooke, who kind of takes this Foucauldian approach to institutional criticisms of marriage. So that's the second question, that what kind of institution is it, and is it helpful for this purpose to even ask that question, to even entertain these shades. The third point is I found a strong resonance between your use of the institutional approach to the legal realist analysis, legal realist traditions of looking at things. So you make frequent references to the background institutional relationship or the background legal relationship. And there is a resonance to the background rules in the legal realist tradition, those background conditions that are not visible. To think about Robert Hale's understanding of contract law. Contract law is in the foreground, but property law is what is in the background. And you might see a freely entered into contract, which obscures the reality of the inequalities created by the law of property. So then this analysis allows us to make the background visible to legal analysis. And that's precisely what you do in your chapter. Fourth point, and which is again, like how my first and second point were intention, here also third and fourth point are intention. I also find that you depart from the legal realist tradition in the sense that for legal realist, coercion is value neutral. So the employer coerces the employee, but the employee also has kind of tools, ammunitions to coerce the employer. And you find examples in the writings of, say, Duncan Kennedy, or even in the Indian family law context, we can see that yes, both the husband and the wife operate within a certain structure defined by patriarchy, but both have resources that they can aim at each other, right? And that's why matrimonial litigation kind of is so long drawn, and not just people use all kinds of things against each other to in their matrimonial disputes. So from domestic violence to provisions in the IT Act to provisions in the IPC and so on and so forth. So coercion is kind of value neutral in the legal realist tradition, but you do not kind of take that position, which leads me to this question: that is there a contradiction in asking the exit question where the parties are clearly at that point of exit? So let's assume that the wife has initiated the divorce, right? So she is clearly at that, she's reached that point of exit in the marriage, and she's kind of initiated the process of exit. Does it still make sense to ask, or does it still make sense to assume that exit is difficult and therefore it's an institution and therefore it's a fit case for the application of the horizontal framework? So that's my fourth point. The fifth point is about resonances to stuff which are already happening in the Indian jurisprudence, particularly in the case of maintenance. So I'll just read out a paragraph from Daniel Latifi versus Union of India. It's a famous 2001 judgment where the Supreme Court basically upheld the constitutional validity of the Muslim Women Act. And this is how it goes. In our society, whether they belong to the majority or the minority group, what is apparent is that there exists a great disparity in the matter of economic resourcefulness between a man and a woman. Our society is male-dominated, both economically and socially, and women are assigned invariably a dependent role, irrespective of the class of society to which she belongs. A woman on her marriage very often, though highly educated, gives up her all other avocations and entirely devotes herself to the welfare of the family. In particular, she shares with her husband her emotions, sentiments, mind, and body, and her investment in the marriage in her entire life, a sacramental sacrifice of her individual self, and is far too enormous to be measured in terms of money. But then ultimately, the court also goes on to say that we have to kind of quantify that sacrifice and that contribution and compensate her, and the court does it through maintenance. And this is just not, I just picked one example, but you find this analysis in a large number of maintenance cases. So one can see, presence of the institutional approach in maintenance jurisprudence. Another rule, which again is something that you mentioned, that you can't waive your right to maintenance through a private agreement. And this is also something that courts have held. I mean, till recently, Muslim personal law was the only exception to this, but now with the Domestic Violence Act, again, it's inescapable. It's a statutory right that you cannot kind of waive through a private contract. So it seems that in maintenance, some of these ideas, in the maintenance jurisprudence, some of these ideas are already there, and yet we kind of reach the limit of it when, in case of in maintenance, as you rightly pointed out, there is no presumption of a 50% default, rule. There is no default division of property. And yet, I wonder if this is a question that we have, I think, repeatedly encountered in these seminars. Is it possible to think of maintenance in equality terms and apply horizontal approach, what would it look like? That's a question I have, and I'll just end with that and hand over to Saumya.
Thank you, Saptarshi, and thank you, Gautam, for your presentation. My responses when I was reading the chapter, there were broadly two sort of first responses. The first was I was wondering whether constitutional remedy would be as effective as a statutory remedy, and I think that question was answered towards the end of the chapter, where you're taking examples from different countries and saying that in a country like India, where there is no statutory framework besides maintenance, this remedy might be useful. The second response was regarding an assumption that seems to run through the chapter. So the approach used in the paper assumes that social reproductive labor that is generated in that domestic relationship is absorbed by the members of that domestic relationship. And usually, in a cis heterosexual relationship, it is absorbed by the woman partner. And households where social reproductive labor is more equally distributed are exceptional. So like in any other law where there is room for judicial discretion and interpretation, such households would fall in that exceptional category, and judges can make a decision on a case-to-case basis. So I want to disturb this central assumption and suggest two things. One, that because cis heterosexual families may also take various forms, there are nuclear families and joint families, the social reproductive labor may not be absorbed by that domestic relationship. The women, it's still gendered for the most part, but the women who are performing this labor may be in different relations with that primary earner. They may be wives, but they may also be mothers and sometimes daughters or sisters. Two, and more importantly, the work generated by this domestic relationship may not be absorbed by people who are related to each other in family law, considered to be family members. So many economists and sociologists who've written about the distribution of domestic and care work have shown that it is often outsourced to underpaid part-time or full-time domestic workers. And it may be outsourced even when the wife is not in paid work, right? So outsourcing is a form of maintaining class and caste status in addition to relieving the domestic relationship of the burden of social and reproductive labor. And here I'm imagining the kind of family that would benefit from the institutional approach, like you've said, a family where enough wealth is amassed to allow for a separation of households at the time of divorce. I would suggest that this is not the exception, it is the norm, outsourcing of domestic labor. So the first question, of course, is will the institutional approach account for the gendered labor of women who are not wives, whether they are family members or not? And do you think it can be used to make the family accountable for the forced labor of these women? Because you're using the term forced labor with regard to the wife's work. The Supreme Court in some judgments, I think that Prabha has also written about in the work on Motor Vehicles Act, has frowned upon this comparison between the work of the wife, the unpaid work of the wife, and the underpaid work of domestic workers. I think that the institutional approach, which seems like a matrimonial property approach, also endorses the same sentiment. Now, I wonder whether this sentiment should be accepted as is, or whether it should be challenged because it values the domestic work of the wife more than the domestic work of an underpaid domestic worker who would be entitled to, let's say, a fair wage, but the wife would be entitled to a share in the property. And the second question is about the impact of these caste and class realities of the distribution of social reproductive labor on the wife's rights. Now, assuming that this is reality for most households, would the wife's demands for equitable distribution of property at the time of separation, as an assertion of her constitutional or legal rights, if there's a comprehensive statutory framework, be justified? So would this fall in the exceptional category where the judge decides to say you did not perform enough social reproductive labor or domestic and care work, and so you're not entitled to this 50 or somewhat equitable distribution of property? Or would the court acknowledge that what she was doing in maintaining the class and caste status of the family in society is also some kind of work? It's just not social reproductive labor as we understand it or we think about. So those are the two broad questions that I had.
Wonderful. That's such a rich set of comments for Gautam. So maybe Gautam, you can respond for a couple of minutes and then we can open it up.
Oh yeah, thanks. Yeah, I think these are fantastic comments and really get to a lot of the issues I was grappling with throughout the thesis and the adaptation part of the thesis. I think, in fact, Saumya's comments reveal the limitations of any model of constitutional rights framework that tries to resolve these kinds of problems. And I think that those are limitations that cannot be surmounted, and that a rights-based approach will always have those limitations. So, for example, your second point about what kinds of labor and the norm or exception. So, actually, interestingly, in the Kenyan family code, they try and define what kinds of labor count. So, care work. So they specifically say care work. They have a thing for a category of emotional labor. So actually, they try and specify that these are what counts. And of course, then there's further litigation around that. And of course, you're completely right in that the outsourcing is more common, is far more common. And in that sense, the chapter basically takes sort of this ideal case situation, where with the assumptions that this is a household that's not outsourced, where it is actually, an inter se relationship. In that case, how would it apply? With the hope being that you can then expand the argument to more complex cases if it first works in the sort of ideal simple case. So that was sort of the objective over there. But I think that you're right in that it becomes much more difficult to apply it to more complicated cases. As far as the question of, Saptarshi's comments, just very quickly. So the exit question, right? So it's already at the point of exit. So the reason why I think it's important is because, as Alan Borg, for example, makes this argument in the labor law context, exit and voice are correlated, right? So the ability to exit a relationship, any relationship, directly correlates with the voice you have in that relationship. So in the labor context, the ease of exiting an employment relationship determines what kind of autonomy you have in that relationship. And so voice and exit are correlated. So therefore, by the idea being that if you therefore alter the exit rules, it tracks back into the voice part of the relationship. And also, just to go back, the reason why it's hard to intervene too directly in the relationship itself is because of the affective part of it, right? So the effective nature of the relationship then makes it hard to have rights directly being applied during the relationship. But if you do it at the exit point, it can be traced back, in time, and create a more equitable relationship during its existence. The other thing, but just to clarify, so as I say in the chapter, this remedy of a default 50% rule on separation is not intended to solve all the inequalities or even a significant part of them. It's one specific aspect. So of course you need wages for housework, you need state intervention, welfare measures, creches, all of that. So this is just one, rights litigation is just one part of a very complex puzzle. And finally, what kind of institution is marriage? Your first question. So it's, I mean, the account is broadly Marxian in its origin, and more specifically, Soren Mao's recent book, Mute Compulsion, where he, takes this institutional gloss on the original Marx. And I'll just quote the line, which also I've used in the book. So the power of it studies the power of individuals as something they are endowed with by a certain social structure, and how social power becomes the private power of private persons. So the idea is not to reify institutions or to give institutions agency. It's still the individual who's exercising the agency, but it is shaped, conditioned, and constrained by their location in the institution. And the two are in a constant evolving relationship. So the institution as a term is broadly in the Marxian sense, of course, as analyzed in more recent interpreters of Marx. So I'll stop there and open it up for questions.
Wonderful. Sorry about that. I've had some Wi-Fi issues. So sorry, Saptarshi wanted to respond to that? Yes, please go ahead.
No, a follow-up question. On the point of, on the exit point, does it make sense to replace difficulty of exit with anticipating the consequences upon exit?
No, completely. So anticipating the consequences is what makes it difficult, right? So the prospect of economic ruin on exit is what makes exit difficult. So maybe difficult might be just giving a misleading impression, but you're right in that it's about the consequences of exit. That's the key thing, and what happens on and how that affects the equities in the relationship. So you're completely right on that.
Okay. Wonderful. Are there any questions from other participants who've been listening? Please do raise your hand. Okay, I think while we sort of just wait for comments, I had two sort of quick. Are you able to hear me?
Yeah.
Okay. Okay, so I guess one of the questions I had, so I just want to pick up on something that Saptarshi said about the allusion to legal realism. Actually, I thought otherwise. I thought for a book that spoke quite extensively about the background seemed to be more the institutional, the power of the institution rather than the power of the background legal rules. I mean, it's you're alluding to it, but it's not fully unpacked. So I just wondered whether you could say a little bit more about the interplay between, because I think we're all invested in a similar project in the sense that arising out of a deep dissatisfaction with a certain set of legal rules, we're trying to unearth what's in the background that, upholds those rules, and that's where the role of the state is very critical. I think once you're more explicitly legal realist, then I think the argument for horizontal application becomes much more straightforward, I think, anyway. But I think the question is more about, what's the interplay between the different sets of legal rules and what is the role of constitutional law? Is it just something that is a placeholder, but is it also something that could be used in a set-off between different sets of legal rules? So I'll just give you an example. In the context of trafficking, so I found, like you, the PUDR decision to be very productive in thinking about forced labor and the role of labor law to counter market coercion. But the way that the Indian state has thought about dealing with coercion or extreme forms of coercion is to use the criminal law against a small sliver of highly coercive behavior in the labor market, but leave unaddressed the vast spectrum of exploitative labor practices. So I think in that context, the constitutional law is also a defense mechanism against the excessive use of the criminal law. So I'm just interested in examples of play between different sets of legal rules. And I think just the second question, taking upon something that Saumya said, I think given that there are secondary labor markets within the institution of marriage, I would think that the horizontal approach could be equally deployed or should be deployed towards those in the secondary labor markets, such as domestic workers.
Yeah, no. So I think that they're both really important questions. So so legal realists, so I study them in chapter 3 of the book, and I study them because they actually make the argument for the first time that what you are treating as neutral or as given actually is the result of human agency, and so for them the state's always involved, right? So that entire distinction between state involvement and state non-involvement, which was the original basis of the US Supreme Court saying that in the civil rights cases that we will not apply the Constitution where the state is not in existence. The legal realists say, look, what you're talking about, the state's always in existence, and what is happening here is the initial distribution of power is legally defined, right? So I think that links into the segue that you made, which is the interplay of rules. So if you look at the classic case that everybody starts by thinking about when they think about this, is Shelley versus Kramer, the racially restrictive covenanting case, where the Supreme Court actually says that we will not enforce racially restrictive covenants in the US, which is a big deal for that time. And for the longest time, people when analyzing Shelley versus Kramer are looking at it in terms of public policy, things like that, until Louis Henkin comes along and writes an article basically saying that what is happening in Shelley versus Kramer is the clash of two sets of legal principles. One being the right to property, which is in the sort of Anglophone common law, one of its corollaries is exclusion of all others, right? So that vis-a-vis the right to equality or equal treatment, so there's no neutral starting point. Whatever decision the court makes, it privileges one set of background rules over the other. And for Henkin, the argument is it should privilege equality rules over property rules. And so I think that is actually the key issue is that what the approach can do in these interplay and clashing situations is effectively play that sort of a kind of a tiebreaker role. So again, in your example of the racist homeowner or other similar examples, you have that private right to the right of private autonomy or privacy or whatever, and you have the corresponding right of equality or dignity and all of that. And without the institutional approach, normally there is some kind of autonomous balancing that happens between the two, which comes down to intuition. So Aaron Barak has a piece on this in some detail. He says that actually, like when we think of the clash between these two rights, in one case it seems that it should come down on one side and the other on the other. So the institutional approach then tells you that actually where this clash is taking place in the institutional context, and where the rights violation is happening because of institutional inequalities, then your private right or your power that is founded in an institutional arrangement therefore deserves to be subjected to constitutional scrutiny, right? Because you yourself are gaining that power from the background institutional framework, including the legal framework, which gives it to you. And I think in that context, the recent book by Virginia Mantevalu on the legal structure of exploitation, where she actually links exploitation to a set of background legal rules in labor law and others, I think is helpful and part of the same, intellectual discussion that we are having. Secondly, on labor markets, yes, I completely agree. I think that obviously I feel that in the domestic work context, that PUDR is classically applicable you don't even have to, go beyond that. It's so clear in what it says about the interplay between Article 23 and minimum wage. But I think that in that context, actually, the point Saumya made, is something that is very interesting because actually then I think she's completely right in saying that when you're deploying the institutional approach to the marital relationship, what you're getting is property rights, and when you're deploying it to this relationship, you're getting a minimum wage. And there's obviously a big distinction there in what you're getting. So there seems to be, in that case, we have to think a little bit more about how we deploy the approach, because there does seem to be a kind of a tension there in that as you sort of go up in terms of the class and the caste composition of the people who are in the institution, the remedies are becoming sort of better, and that of course is something we have to think about. So I think that yes, applicability wise, it definitely it can help, but I think what Saumya said makes me think a little bit more about how we have to then deal with the fact that the different institutions at play then are affecting the remedies in different ways, and if that's leading to results that you want to think a little more about.
Great. That sounds wonderful. Thanks. Are there any other questions for Gautam or for the respondents? Yeah, Hardik, go ahead.
Hi. I hope I'm audible.
Yes.
Yeah.
Hello. So essentially, I wanted to ask two rather different questions. The first one was that you had limited your analysis in the chapter to cis heterosexual relationships, and a primary reason for that was cis heteropatriarchy and how much research there already exists on that. But I wanted to know what your opinion would be on the gaps between the power imbalances that occur due to class, caste, and other differentiations between partners in these relationships, and how that could be seen by constitutional courts or even courts giving these remedies. The second question relates to, actually, you could just answer this. I'll come to the second question.
Yeah, no, I mean, so I think that the reason, as you rightly said, the reason why I picked this sort of relationship is because, of course, like A, sort of applicability across the board. So it's not just an India-specific thing, and B, that when you're trying this new approach, I guess you first try and do it in the most basic way, and then see if it works there, and then try and expand that. So I think the problem that you've raised is basically broadly a problem of intersectionality, like in broad terms, which is that even within the domestic relationship, you will have different intersecting institutional axes of power difference. And I think that again, so I don't know how a court can navigate like multiple institutions being present in the same sort of case or in the same claim. But I would imagine that it would be you would have to apply each sort of axis as you're applying it with respect to the claim, right? So if to the extent that if the claim is for equal division of property, on separation, if that's the remedy, then that traces back to a very specific kind of gendered power imbalance that takes place through the relationship where one spouse acquires property in their name because they have the financial means to do so, because their work is productive and paid for, whereas the other spouse is deemed to be not and unpaid. I think that what would happen then is that for other axes, you would then have to fashion remedies that are responsive to those axes. So what might the caste sort of difference of power result into? What kind of inequality or what kind of rights violation would then determine the remedy, as with class as well. So I think that's what you have to do. I think the other difference, of course, is that that class and caste are both not inherent within the cis heterosexual relationship, because like they could be added on in specific relationships, whereas what we're dealing with is an inherent feature of these relationships by definition, by stipulation in the chapter. Right? So in that context, I think you may have to have a totally different study in that case that links the two, and then you may have to then have different remedies as well. So I think that's work for the future, and that's something that isn't answered, I think, right now, at least not in this chapter.
Yeah, thank you. A second question was just generally, given the recent judicial self-disempowerment that has happened with respect to regulating marriage as an institution in India. For instance, in Suprio, where because of the customary practices and religion involved, for example, in Justice Bhart's opinion, the state's non-involvement in the creation of the marital institution was fatal to any regulation which went outside of customary practices or religious practices. My question essentially relates to how this judicial self-empowerment impacts any application of the horizontal rights approach to the institution of marriage. And this is a course that particularly can be seen all across the world, not just in India. So what is your view on that?
Yeah, so I think that's sort of, a foundational critique, right? So any I think any intellectual project that vests responsibility, that is has so many moving parts and is this complex on judges, I think the foundational critique that they're fundamentally and structurally not the best actors to discharge a responsibility of that kind. I think that the more we see, the more we come around to that view. So I think that I think is like a problem, a limitation of any such project, that ultimately places a certain amount of heft in the adjudicatory process. So I think that is well taken. I think what I would say is then that we have to obviously separate then in that case the theoretical part of the argument from the judicial part of it, and even if we say, okay, look, the theory is well and good, but obviously given the way courts act and courts' own institutional location within the broader state structure, it's unlikely that it'll find genuine purchase in the courts. But then, of course, constitutionalism can exist beyond courts as well, right? So I would then just separate the two parts of the account and then say that, look, then the answer is to try and articulate these arguments in other forums where they can maybe find some purchase before they come to the litigation sort of framework.
Okay, thank you. Thanks a lot.
Great.
But yeah, this was actually an issue that really cropped up when I was working on the labor law chapter, the chapter before this, because there's this whole tradition of left critique of labor legalism, which says that you do more damage by constitutionalizing a labor dispute than by just not bringing it to court. So that's something that I think again it infects these kinds of accounts throughout, and you have to grapple with that and say, okay, look, this is obviously a very fair point. And in that context, basically, so one thing that the book does, and this was, I think, this happened in iterations through the writing of the project, was that over the course of multiple drafts, the focus on statutory frameworks and legislation became much more than it was in the beginning. And so thereby, again, that the role of the courts went from being almost drivers of the approach to working in the interstices of the legislation and the constitution. So much more modest, constrained role, more interpretive role than being drivers of it.
Mm-hmm. Great, thank you. Are there any other questions or comments? Are there any further thoughts from the respondents? So actually, Gautam, if you could just say a little bit more about the labor law chapter, I think that would be quite interesting, because I think also because it's a bit like unpaid work. It's it's not easily amenable to a standard employment contract, right? The question of gig work. So it'd be interesting to take contrast something which has existed forever, meaning unpaid work, vis-a-vis gig work, which is, in that sort of zone of informality, very high levels of informality. How the law can respond to that.
Yeah, so with platform work, what's been happening so far, I think as many of you know, is that the classical labor law is late 20th century labor law is based on the idea of the factory floor or the shop floor as the site of the law. So employer, employee, employee being with one employer, fixed hours of work with overtime, of course, the machines being the owners, machines on the factory, all of that, right? Of course, platform or gig work is not new. There was piece work in the 18th century, BD work in India after independence. In many cases, which it's almost akin to platform work, but just without the online platform. And labor laws always had problems with that category of work. And so throughout the world, labor law is based on this employee and contractor binary. So if you fulfill certain criteria of permanency, one employer, machine, who owns the machine, all of that, then you are an employee, and then you have protections under labor law, right to strike under certain circumstances, right to unionize, right against unfair labor practices, all of that. If you don't fulfill those criteria, you're a contract worker, and you basically have very few rights. And so so employment status becomes a gateway to accessing labor rights in most of the countries around the world. And so all the platform work cases from the US states to the UK, the Uber case, to Spain, to Netherlands, the Deliveroo case, to the European Union, to Australia, have been battles over the status of an employee. And they've been decided based on the statute, and they've gone both ways. And one really common argument is what they call the substitution argument. So one common criterion for not being an employee is what they call substitution clauses. You can substitute, for someone else. So there are many things of this kind. So the argument in the labor law chapter is that you deploy the institutional approach to platform work. So I begin by establishing that the labor market is an institution in the context of the book, and obviously it creates of capital and those who do not own capital. So it's sort of a pretty classically Marxian approach there, looking at labor market, power based on the ownership of capital. And so having then established that the horizontal rights approach can apply to the labor market, then the bite, of course, is in the application. And there the argument I make is that the core of the institutional power difference between the worker and the platform is the algorithm, because the algorithm determines the terms of the relationship. It is a disciplining entity in that you get kicked off the platform if your ratings fall below a certain level. Therefore, there's an element of administrative decision making leading to loss of livelihood, discrimination, as you all know, big issues over there. So basically, the site of the institutional power difference is the algorithm, and therefore I argue that the correct test is actually not whether the Uber driver owns their own car, because the classical test is okay. If you own the machine, then you're a contractor, because the machine is the source of your autonomy as a laborer. Whereas in this context, you're owning the car actually is not the source of that power equalization. It's actually the algorithm that determines that. So basically, I argue that many of those classical tests, therefore, have to be displaced in the platform work context, and the institutional approach that asks, look, where is that difference in power coming from? It helps you to understand platform work in the context of labor law rights better, and then to interpret the gaps in these labor law frameworks across the world in a way that vindicates the rights of the workers. And then I also argue that it takes you a little further as well. Right? So one common argument that's made is that the algorithm is proprietary, and so therefore issues around property rights and intellectual property, the platforms use that in order to avoid any kind of scrutiny over the workings of the algorithm in setting prices, setting wages, setting rates, discipline, and so on. Whereas if you apply the horizontal rights approach and constitutionally and properly, then there are strong arguments for algorithmic transparency. Now, of course, there is a strong movement for algorithmic transparency in platforms across the board. So this sort of tries to provide some constitutional and legal policy and support, and try to articulate that demand in constitutional language for anyone who might need it. So that's effectively the argument. The argument is that the institutional difference in power between the platform workers and the platform flows from the algorithm and how the algorithm works. That's what defines the relationship. It's a price setter, it's a disciplining entity, all of that. And then that in turn justifies the application of constitutional rights to the relationship between the worker and the platform. And given that in most cases there exist labor codes, you don't have a labor code in the constitution. So what this does is that it provides a reason for existing labor law to be extended to platform workers, and whether the dispute over whether it does or does not, a reason for saying it does extend to them. One of the cases I analyzed was this, I think, case involving delivery workers, the Court of Appeal at the time. So that went to Supreme Court, and I think Supreme Court of the UK just a couple of months ago said they're not workers. A disappointing judgment for, I think, labor lawyers in the UK. But in other cases, they've said that they are, like in Uber's case, intermediate limby workers and so on. So that's where the state of play is on that.
Okay, thank you. Any other questions? So, sorry, Gautam, I had a question. I mean, are there other such institutions, well, not necessarily as grand as the labor market or the family, but are there other centers of power that one could productively use the horizontal approach in relation to? And I guess also the second question about, you talk about a few of the Indian Supreme Court and its creative arguments in 3 of those instances. But I'm just wondering about the take-up of some of those arguments. So the PUDR decision has been kicking around for a very long time, but the take-up of it is unusually kind of low. So I'm just curious about, whether you had any thoughts on that. I mean, how much of a reach? Because obviously, there are feminists on the call actually who've been thinking about this for a very long time. I think there are family lawyers with decades of experience who've been thinking about how does one constitutionalize family law, right? And it seems to be sometimes seems to be very, very challenging. So if you have some sort of thoughts on openings or ideas for strategic litigation, I think that would be really something we could think with.
Yeah. So on the first question,
yeah,
sorry, go ahead.
Could I just add one bit to what Prabha asked? The question of maintenance, which was my final point, that we have all the elements of an institutional approach in the maintenance jurisprudence, and it seems unlikely that we're going to have a statutory, a community of property. Community of property legislation anytime soon. I don't think that's going to happen. So if you were to look at code-based approaches, then is it possible to how can we extend the resources that we have in family law jurisprudence now to turn maintenance into a constitutional horizontal remedy?
Yeah, so I think first on this broader question of other institutions. So yes, actually, many of the cases I study have other institutions. So the Jamaican case, there the mass media was that the private mass media was the institution. Even smaller in the Kenyan case, clubs, because historically in the colonial era, the clubs were the sites of enforcing the color bar. So a private club was where you would enforce that social segregation, the social hierarchies. And so actually the second order passed by Jaramogi Oginga Odinga, the Home Minister on Independence, was actually prohibiting private clubs from discriminating on grounds of race. Of course, he left out gender. It's not surprisingly, given how many of these independence movements, of course, were themselves that the problems with gender equality. And then 50 years later, the court says actually, given the role that clubs play, the right to gender equality can be applied horizontally vis-a-vis the women members and the club. So in that case, then clubs, for example, your classic case of a smaller institution. In South Africa, private schools, constituted that institution where they applied horizontally. So yeah, I think that's there. Of course, the smaller it gets, then it's sort of many of the considerations then start to weigh against applying the constitution directly, given that the ease of exit, all of that. So I mean, ultimately, these institutions have to exist at some kind of scale, because the smaller they get, then the more the push for using your normal private law to resolve that problem over there, or contract law, public policy, all of that. But to answer the question, there are all these institutions as well. The second one on strategic litigation, so I think that there are 2 or 3 things here, right? So one is that like a lot of what's possible depends on the broader climate, that exists outside of the courts, which the courts are not immune to. So in that context, there might be, say, more scope at a given time for this kind of litigation in, say, a South Africa or a Kenya than in India, whereas at some other point of time, 20 years later, or perhaps 20 years earlier, it may be more possible in India than in, say, Kenya. So I think this is a cyclical thing where opportunities open up based on a lot of other factors as well. And I think one, of course, core feature is to know when that climate is there, where you can push most effectively. And I think the other thing, of course, is that that I think one thing that at least I've realized, and I think we always knew this in theory, I think it's become much clearer, specifically with what happened with the equal marriage cases, was that that the more radical the remedy you're seeking, the more innocuous you should make it sound, right? So just like the equal marriage case, you shouldn't begin with asking for marriage, but if you begin with asking for something innocuous like rental equality, which was what happened in the UK, the first case where they interpreted the statute in neutral terms was Gedan Mendoza was Godin, which was a rent discrimination case. So they interpreted husband or wife as if husband or wife as spouse, in order to make rent, and then you go from rent to inheritance, from inheritance to tax, and then when you've already sort of altered the legal landscape bit by incremental bit, then in the end you ask, if you want to ask, you ask for something like marriage. So I think something similar has to be done for what we are discussing. So when you're constitutionalizing the family, then to look for these little interstices where something that doesn't seem or feel outrightly radical to the court then becomes the hook or the window in, and then sort of you try and go incrementally through that. I think that in fact the motor vehicles case is an excellent example, right? So you build up a body of jurisprudence through the motor vehicles cases, which now recognizes unpaid domestic work as productive labor and as something that has to be quantified. And then, for example, let's say, so Saptarshi's example of maintenance, you don't start by making a claim for community of property, or by making a claim saying for equal dissolution, but you begin by making the claim that, look, all these motor vehicles cases have established that you have to quantify unpaid work. So now in so-and-so case, you transport that jurisprudence and begin the quantification of unpaid. It's already happening. I think this last week, in fact, there was some judgment that did that. And so then you build up again from there eventually with a view to getting something like equal division of property. So I think that, I mean, the brief answer being that I think what's more effective is in terms of strategy. If we want something like the institutional approach to inform, and to have the constitution applied to the family and to the workplace in a broader climate where there is not too much sympathy for these kinds of arguments, I think that the way to go is to do it in sliver-sized pieces, where the individual claim is something that's sympathetic and would and makes sense, and then to put the slivers together over time into sort of a quilt of jurisprudence, basically, right? So I think that's what I think historically has worked, and should work, I think, going forward as well. So if we can isolate those interstices and then work to interpret the law in those cases in the way we want, then we might be able to have progress, bit by bit.
Great. I think that in a way also answers my other question about why there hasn't been take-up of certain constitutional arguments. I guess because we tend to make the sort of bigger rights claims rather than saying, well, how about this, very powerful, legal principle that could actually produce radical results. But yeah, okay.
Yeah, I think it's actually, I mean, if you look at a case like PUDR, right, I think the reason why it hasn't had uptick is because it comes out of nowhere, basically, right? So there's nothing before PUDR really that gives it a foundation. It is sort of, I think it comes out of the judge's head, basically, right? Like it effectively. So and then that obviously means it can't stick, right? So there's no thing around, and I think even Sabrimala judgment, right? The analysis of horizontality in Justice Chandrachud, as he then was, his judgment hasn't stuck because, again, there was nothing before it. And so where do you ground that in, right? So if you just go straight to the big claim, it normally doesn't stick, at least in the courts, So, yeah.
Great. Wonderful. Great. Are there any final questions for Gautam? Or observations? If not, I just want to thank Gautam very much for his presentation and his wonderful book, and to our respondents as well for engaging with his work so thoroughly, and to all of you for joining us today. So there'll be a recording of this event in case you have friends who missed it today, which will be put on our website. But in the meantime, here's the link to Gautam's book. Please do buy a copy, and thanks, Gautam, for a very...
So I just add to that it's unfortunately at an academic price, and all efforts to get them to do a South Asia edition so far have been met by stony silence. So I encourage all of you to use other methods, using the online space to get copies.
All right, you're happy with us doing that, and okay. That's truly radical. Okay. Okay, well, thanks very much, and we will definitely download our copies and circulate the copies we have on hand. So thanks a lot, Gautam.
Yeah, thank you so much. It was wonderful. Thank you so much.
Yeah, great. Thanks. Bye.